don't get a lot of family law cases before the Wisconsin or U.S. Supreme Court. So when we do get one, it's pretty interesting and well worth reading. And there was one that came down earlier this month from the Wisconsin Supreme Court. It's the only family law case pending in front of it. And involves the difficult issue of grandparent visitation. The case is called Meister versus Meister, and you'll read a summary of it in this month's Flu. And I just want to talk about a couple of my reactions to the case. It is based upon an interpretation of Wisconsin statutes regarding what grandparents have to prove in order to have a right to petition for visitation with their grandchildren, and involves some statutory interpretation. I'm not contesting the Wisconsin Supreme Court's interpretation of Wisconsin statutes. And if you read the summary in this Flu, you'll find out that what the Supreme Court decided is that the Court of Appeals and the trial court erred in finding that the grandparents hadn't met the minimum requisites to be able to petition for visitation. I'm not questioning the technicalities of the statute. I'm not questioning that the Supreme Court didn't get that part right. But I'd like to go backwards a bit to a United States Supreme Court case. I said that Wisconsin Supreme Court cases in this field are rare. U.S. Supreme Court cases are even more rare. And there was one a number of years ago called Troxel versus Granville, which dealt with the issue of third-party visitation. Troxel's a difficult case on its facts because it involves the type of grandparent issue where your heart really goes out to the grandparents. It was grandparents who had a close relationship with their grandchildren. Their son, their grandchildren's father, dies, and the mom remarries a man who then adopts the children, thereby creating a new intact family. And under the law, we treat parents who adopt identical to those parents who have children the natural way, and that's the way it should be. So now we have a new intact family, and they don't want the biological father's parents involved with the children. Troxel involved something like 6 different opinions, and you have to try to figure out which portion of which actually had 5 votes. But the way the case is normally read, by adding up the various justices, and I think correctly, is to say that fit parents have a constitutional right to parent in the manner in which they wish to. And it makes sense in that I don't believe fundamentally that our legal system and courts should be involved in making parenting choices as long as the parents are fit and able to do so, and are able to do so to a reasonable degree. I don't think we ought to get involved in the nuances of parenting from a judicial point of view, and that's partially due to my overall philosophy that litigation and parents fighting is bad for children. The Wisconsin Court of Appeals, in a case called Rogers, interpreted Wisconsin statutes in a manner to be consistent with Troxel, and said that grandparent visitation, therefore, has to be subject to what everybody adds up as the 5 justices that come together at some point in Troxel to say that fit parents have a constitutional right to parent as they wish to. The problem is that from an emotional and sympathetic point of view, your hearts have to go out to the grandparents who have not only lost their child who died, but here are the remnants of their child. Here's the remaining bits, their grandchildren, what's left of their child who died, and we're allowing, for perhaps no good reason, this new intact family to perhaps completely cut them out. As a grandfather myself, I can't imagine how difficult and how horrible it would be for those grandparents to have that happen to them. But at some point, we have to make a decision as to priorities, and our legal system does a lot of that. And in our sense of priorities, the children's interests are always held and should always be held paramount. The problem with the Supreme Court decision, once you get past the statutory interpretation and deal with what I'm worried will be a watering down of Rogers, the Wisconsin case, and more importantly, Troxel versus Granville, is that it can lead to more litigation, more grandparents seeking to have legally mandated access to their children, and it can lead to some bad results. I mean, picture a case where maybe there are two sets of grandparents that are both alive, but both divorced, that both remarried, and we got four sets of grandparents, and they all want a weekend, and if they all get them, when's this family ever going to be together? And then imagine a family, a mixed family with his and hers and ours, and God knows how many grandparents can be involved. And I'm not saying that would happen in every case, but it certainly has the risk of it. And I think when we make the decisions and the choices in this matter, that some of that has to take into account that regardless of the results, and that the court can deny placement and say, this is too much in this individual case, that the act of litigation in and of itself, the act of fighting, does two things that are bad for children. A, children don't like fighting. Children are inherently peacemakers. And then second, the cost that can be spent on this is probably good for a couple of college educations, or at least a few tuitions. As a result, I'm worried about this case. I'm concerned about it. And if the Supreme Court may have gotten the technical law correct, I'm worried that they missed the forest because of the trees, and that the best interests of the children would not be served by trial courts making the correct decision, which the Supreme Court seems to believe they have confidence will happen. They're right in most cases, but they seem to think that that's enough. And I'm thinking that even if they do reach the right decision, it's after parents have fought and litigated, and that in itself is bad for children. I'll be dealing with some of the technicalities of the decision in terms of the statute, and also a bit on my thoughts on the case like I just explained in my column in Inside Track, the online publication by the Wisconsin Bar Association. Should be emailed to members of the State Bar. May 18th, I believe, is the publication date. And if you're interested, take a look at my column, and always welcome emails and comments on what's a very, very difficult issue.